Meetings. Meeting means coming together or an assembly of persons in a particular place to discuss lawful business of common interest and based on opinions expressed by participants take decisions in the form of resolutions. Meeting of members is the first type of meeting. Member in relation to a company are three types. One, subscriber to the memorandum with the name entered in the register of members. Second is those who have agreed in writing to become members and therefore their entry in the register of members. Third is as beneficial owners holding shares on behalf of others, name entered in the records of a depository. Members meeting can take the form of annual general meeting which is held each year and the notice will specify it is an AGM. Between two AGMs, the gap will not be more than 15 months. The first annual general meeting can be held within 9 months after the year end, whereas subsequent annual general meetings have to be held within 6 months after the year end. However, in respect of subsequent AGMs, ROC is entitled to give an extension of 3 more months. AGM has to be held during business hours and the day should not be a national holiday. It can be held at the registered office or within the city or village where the registered office is located. If the company fails to call an AGM, a member can approach tribunal which can issue an instruction to convene the meeting, including a direction that even one person present can constitute a meeting. Extraordinary general meeting is another type of meeting of members called by board. It can also be called based on requisition from members who hold 1/10 of the paid up capital or total voting power. The requisition should include the nature of business that the shareholders want to transact thereat. If the board doesn't convene the meeting, the requisitionists themselves can hold the meeting within 3 months from the date of requisition. The cost of holding such meetings can be reimbursed by the company and the same can be deducted from the remuneration payable to the defaulting directors. Extraordinary general meeting can also be ordered by the tribunal where the company finds it impracticable to convene a meeting other than an AGM and the tribunal, suo motu or based on application from any director or member can convene the meeting and also issue an instruction that even one person present can constitute the meeting. The second type of meetings is the meetings of directors. Directors are individuals who direct, control or manage the affairs of a company. The first meeting of the board of directors will be held within 30 days of incorporation and in an year a company is supposed to have 4 board meetings and between 2 board meetings the gap should not be more than 120 days. The third type of meetings is that of class. It might pertain to a class of shareholders for effecting variation in their rights and privileges or for conversion of one class into another, which should be permitted by memorandum or articles and it should not be against the terms of issue. Any resolution passed for variation must be supported by a majority of 3/4. Class meetings can also be meetings of creditors or a class of creditors. The meetings are normally called by the court on application from the company or the liquidator. Whatever resolution passed in the creditors meeting should have support of 3/4 of value of creditors and it should also be sanctioned by the court to be binding on all the creditors. Meeting of debenture holders is another type of meeting where the meeting is held in terms of debenture trust deed or debenture bond and these meetings are held mainly to have variation in the rights of debenture holders during reorganization, reconstruction, amalgamation or winding up. The meeting of contributories and creditors convened by the liquidator, sometimes with the support of court to get their acceptance to the compromise or rearrangement to save the company, and contributory is one who is liable to contribute to the assets of the company when the company is being wound up. In the course of convening any meeting, notice comes first. Notice of a general meeting has to be a clear 21 days notice in writing or through electronic mode. If consented by members holding share capital to the extent of 95% or total voting power to the extent of 95%, a shorter notice may be given to convene a general meeting. The notice shall specify the place, date, day and hour and also the statement of business to be transacted at the meeting. Notice has to be given to the member, to auditor and to the director. Any accidental omission while giving the notice shall not invalidate the entire proceedings. With the notice will be attached an explanatory statement in respect of each item of special business, which comprises a statement of material facts indicating the nature of concern or interest of director, manager, or other key managerial personnel in the business to be transacted. The purpose of an explanatory statement is to enable members to understand the scope and implications of the item of business before they take a decision on the resolution. Explanatory statement pertains to special business. In an AGM, all business is deemed special other than four. 1. Adoption of financial statements and accounts. 2nd, declaration of dividend. 3rd, appointment of directors in place of those retiring. 4th is appointment of auditors. However, in other meetings, all business is deemed to be special. Where any item of business refers to a document, the notice should indicate the time and place where such document can be inspected. When in a meeting, members want to move a specific resolution, they can give a requisition and deposit the resolution with the company 6 weeks before the meeting, and if they want to circulate any statement in this regard, they can deposit that ahead of 2 weeks. Company is bound to circulate the notice to all members along with the statement as relevant. Only condition is the requisitionists are required to deposit sufficient money with the company to give effect to their request. As regards matter to be circulated at the instance of requisitionists, the company or any other person who claims to be aggrieved can approach the central government to get an order to the effect that the circulation need not have to be done, as the provisions are being abused to secure needless publicity for defamatory matter. 2 specific resolutions require special notice. First resolution pertains to appointment of a person as auditor at the annual general meeting, providing expressly that the retiring auditor shall not be reappointed. And the second resolution pertains to removing a director before expiry of his tenure and appointing someone in place of the director so removed. To be eligible to issue resolution of special notice, the member has to have voting powers to the extent of 1% of the total, or the paid up value of shares held by the member has to be not less than rupees 5 lakhs. The resolution with special notice has to be deposited with the company at least 14 days before the meeting, so that the company can give 7 days notice to the members. Where the company finds it impracticable to give a notice of 7 days to members, it can give an advertisement in an English and vernacular daily containing the special notice 7 days before the meeting. After convening comes constituting, and quorum is the first element of constitution. Minimum number of members for transacting business at a meeting is called quorum. Unless articles otherwise provide a large number, in case of a private company, quorum is 2 members personally present. In case of a public company, depending on the number of shareholders, if the number of shareholders is not more than 1000, quorum is 5 members. If the number of members is up to 5000, it is 15 members. And if the number of members exceeds 5000, quorum is 30 members. If the quorum is not present within half an hour from the time appointed for holding the meeting, if the meeting was called by requisitionists, it shall stand cancelled and closed. Otherwise, the meeting shall stand adjourned to the same day, next week, same time and place. If it is some other time and some other place, board has to give a 3 days notice. If at the adjourned meeting, once again, if the quorum is not present within half an hour, the members present shall be the quorum and they can continue the meeting. The second component of conducting a meeting is chairman. Every meeting must have a chairman and is elected in a proper way and is expected to act in an impartial manner for the benefit of the company. Subject to articles, members present can elect the chairman on a show of hands. If a poll is demanded on the election of chairman, it shall be taken immediately. The chairman elected on show of hands continues until some other person is elected chairman as a result of poll, and such other person elected on poll will be the chairman for the rest of the meeting, and a chairman is entitled to a second or casting vote in the case of an equality of votes on an ordinary resolution. The third important component of conducting a meeting is proxy. Proxy is an agent appointed by a member to attend and vote on his behalf. Proxy also means the document by which such an agent is appointed. Between member and the proxy, the relationship is that of principal and agent. A proxy need not be a member of the company, and a proxy can be revoked in 3 ways. 1. By deposit of a new proxy within the stipulated time, or by the member himself attending and voting before the proxy has voted, or by revocation. Something more on proxy. A member entitled to attend and vote is entitled to appoint another person as a proxy. The instrument of proxy shall be in writing and it shall be signed by the appointer or his attorney. It has to be deposited with the company 48 hours before the meeting. A proxy cannot speak in the meeting. He is not entitled to vote except on a poll. A person appointed as a proxy can act as such on behalf of maximum 50 members. Giving 3 days notice in writing, a member may inspect proxies as lodged with the company during business hours, starting 24 hours before commencement of the meeting and ending with the conclusion of the meeting. Two interesting points on voting. When calls are in arrears in respect of shares, articles may provide that no member can exercise any voting right in respect of such shares, and no voting rights can be exercised where the company has exercised any right of lien. Another interesting point is on a poll, a member entitled to more than one vote, either directly or through his proxy, need not have to use all his votes. And whatever votes he casts, he need not have to cast the vote in the same way. Whenever a resolution is put to vote in a general meeting, unless a poll is demanded or there is electronic voting, the default method of decision is voting by show of hands. A declaration by the chairman on passing of the resolution or otherwise by show of hands and an entry to that effect in the minute books shall be a conclusive evidence of the fact of passing of such a resolution or otherwise. In a meeting, poll may be ordered before or after declaration of result using show of hands. A poll may be ordered by the chairman on his own motion, or it can be ordered on a demand made by shareholders who hold by person or by proxy not less than 1/10 of the total voting power, or a paid up capital with an aggregate value of not less than rupees 5 lakhs. A demand for poll shall be taken up immediately in two situations. One, when it is demanded for adjournment of meeting. Two, when it is demanded for appointment of chairman. A poll demanded on any question other than the two shall be taken within 48 hours. The chairman of the meeting shall have the power to regulate the way the poll shall be taken, and the result of poll shall be deemed to be the decision of the meeting. Electronic voting is mandatory in respect of listed companies and a company having shareholders not less than 1000 when it comes to voting facility at general meeting. The notice of meeting will be sent by registered post or by electronic means or through courier. It shall also be posted on the website of the company. 21 days before the general meeting, the company shall issue a public notice by advertisement specifying the business can be transacted by electronic means. It will indicate the date and time the e-voting commences and the date and time the e-voting ends. The facility of remote electronic voting will be open for not less than 3 days, and it shall close at 5 p.m. on the date preceding the date of the general meeting. One who attends the meeting personally, who have not already cast their vote by remote electronic voting, can exercise their right at the meeting through electronic voting system or by ballot. Electronic voting is flexible, but once vote on a resolution is cast by the member, not allowed to change it subsequently. One or more scrutinizers are appointed by the board of directors who shall count votes cast at the meeting, unblock votes cast through remote e-voting. They will make a consolidated report to the chairman 3 days from the conclusion of the meeting, and the results are declared along with the report of the scrutinizer and placed on the website. On receipt of requisite number of votes, resolutions are deemed passed on the date of the general meeting. Postal ballot is another component of conducting the meetings. Central government may require companies to transact certain items of business only by means of postal ballot, but ordinary business where directors and auditors have a right to be heard at any meeting are outside the scope of postal ballot. Facility to vote by electronic means are to be arranged in respect of business under postal ballot. Notices are sent in the normal course by post, email, courier, also placed on the website. Advertisement published in vernacular and English newspaper about dispatch of ballot papers. Postal ballot involves voting by post or electronic means within 30 days from the date of dispatch of the notice. The results are declared along with the scrutinizer's report with the placement on the website of the company. As regards postal ballot, a few of of the items of business to be transacted by postal ballot under section 110 subsection 1, alteration of objects clause of memorandum, alteration of articles to insert or remove provisions under section 2 subsection 68 for constituting a private company, change in place of registered office outside local limits, issue of shares with differential rights, sale of the whole or substantially the whole of an undertaking, or buyback of shares by a company under section 68 subsection 1. Resolutions are an essential part of the conduct of a meeting. A motion, when passed by requisite majority, becomes a company resolution. Resolution is the formal decision of a meeting on any proposal placed before it. It shall be an ordinary resolution if the notice required under this act has been duly given. It is required to be passed by votes cast in favor of the resolution exceeding the votes cast against, including the casting vote. The votes may be cast through vote in person or by proxy or by postal ballot, and it can be on a show of hands or electronically or on a poll. Ordinary resolution is sufficient enough for declaring dividend, appointment of auditors, electing directors, or to pass the annual accounts. As regards special resolution, it is necessary that the intention to propose as a special resolution has been specified in the notice calling the meeting, and regarding the votes cast in favor of the resolution, whether by show of hands, electronically or on a poll, vote in person, proxy or postal ballot, the votes cast in favor shall not be less than 3 times the number of votes cast against the resolution. As regards a resolution passed at an adjourned meeting, it shall be treated as having been passed on the day on which it was actually passed. Regarding documents in electronic form, every listed company or a company having not less than 1000 shareholder family may maintain its records in electronic form. But the requirement is the records may be register, agreement, memorandum or minutes. It must be capable of being readable, retrievable and reproducible in printed form. Once dated and signed digitally, should not be capable of being edited or altered, and it shall be capable of being updated according to provisions of the Act, and the date of updating shall be capable of being recorded on every updating. Under documentation, second aspect, minutes of meeting. Every company shall cause minutes of proceedings to be prepared, signed and kept in such manner as may be prescribed within 30 days of the conclusion of every such meeting. The books kept for the purpose will have their pages consecutively numbered, and they will be very comprehensive, covering every general meeting of any class of shareholders or creditors, every meeting of board of directors or every committee of the board in its meetings, and of every resolution passed by postal ballot, and of all appointments made at such meetings. In respect of minutes of the board of directors meeting or a committee of the board meeting, names of the directors present and names of the dissenting directors in respect of each resolution shall be recorded as a part of the minutes. In respect of minutes in general, chairman shall exercise absolute discretion for inclusion or otherwise of any matter in the minutes on the grounds specified in the Act. As regards minutes as a matter of evidence, it shall be evidence of the proceedings recorded therein. The books containing the minutes kept at the registered office of the company, opened during business hours to the inspection by any member without charge, and available not less than 2 hours each business day. Members shall be entitled to be furnished with a copy of any minutes within 7 working days on payment of relevant fees. As regards filing resolutions and specified agreements, a copy of every resolution or any agreement specified in subsection 3 together with the explanatory statement shall be filed with the registrar in 30 days of passing or making thereof. Every copy of resolution which has the effect of altering the articles and every copy of agreement referred to in subsection 3 shall be embodied in or annexed to every copy of articles issued after passing of the resolution or making of the agreement. As regards matters specified in subsection 3 of section 117, the provisions shall apply to special resolution, resolutions which have been agreed to by all members, any resolution of the board of directors or agreement executed relating to appointment, reappointment, renewal or variation of the terms of appointment of a managing director, resolutions or agreements which have been agreed to by any class of members, resolutions requiring a company to be wound up voluntarily, and resolutions passed in pursuance of section 179 subsection 3 by a board meeting for buyback, borrowing or investing and related matters. Filing reports is a concluding part of documentation. Every listed company to prepare a report on each AGM to file with ROC within 30 days of conclusion of the AGM. It contains day, date, hour, venue, appointment of chairman, number of members attending, quorum, compliance with respect to calling, convening and conducting the meeting, business transacted at the meeting, It is a fair and correct summary of the proceedings, and it shall be prepared in addition to the minutes of the meetings. Progress review of company meetings. Every company has to hold a general meeting every year, and it is called annual general meeting, and it should be held on a day when it is not a national holiday. First annual general meeting is given a time concession. It can be held within 9 months from the date of the end of financial year. However, subsequent annual general meetings should be held within 6 months of the closure of financial year, and there is one more requirement. Between two AGMs, the gap should not exceed 15 months. A notice in writing or through electronic mode is required to be given to members in respect of a general meeting, and the notice has to be given 21 days in advance. In respect of an adjourned meeting, the company need to give a notice of not less than 3 days to the members. Every member who receives a notice to attend is entitled to appoint a proxy. The proxy has to be deposited at the registered office of the company at least 48 hours before the conduct of the meeting. A person can act as proxy for a maximum of 50 members. The total value of proxy which is held by one person should not exceed 10% of the share capital or the voting rights. In a private company, quorum required is 2 persons personally present at the meeting of the company. In case of public company, there are 3 slabs. Up to 1000 members, quorum is 5 members physically present, where the members of the company are from 1001 to 5000, quorum is 15, and if the members are more than 5000, the quorum is 30. At the meeting, the members who are personally present normally select a chairman among themselves by show of hands. However, if the article provides any other method, they will follow that method. In a general meeting, normally all resolutions are passed by a show of hands. However, there can be a method of poll also, voting. A poll demanded on any question, the chairman has to take up within 48 hours of the demand. However, there are 2 demands which are to be attended immediately. First demand is demand for adjournment of the meeting. Second, demand for appointment of chairman. If a chairman has to go through poll and the poll elects a chairman, then the new chairman who is elected by poll will replace the chairman who was selected by show of hand. In the poll, there will be scrutineers who will be collecting the details of the poll and then processing them. They will submit the report to the chairman within 7 days from the day the poll is taken. Section 108 deals with voting through electronic means, that is e-voting. The e-voting, when it opens, it will be open for not less than 3 days, and it shall close at 5 p.m. on the date preceding the date of general meeting. And whoever has not voted in e-voting, he can attend the general meeting and cast his vote inside the meeting, either online or physically. Once the vote is cast by e-voting, he is not allowed to vote at the meeting once again, but he can attend the meeting. A copy of every resolution has to be filed with the registrar once it is passed in the meeting. An AGM is completed within the next 30 days. The report of AGM shall be filed with the registrar. As per section 92, a company has to prepare an annual return in the prescribed form MGT7, and the annual return has to be filed with the registrar within 60 days from the date of annual general meeting. The annual return will be signed by one of the directors and the company secretary, and where the company is a listed company, the annual return will also be certified by a practicing company secretary. MGT9 is an extract of annual return prepared by the company, and it shall be attached to the report of the board of directors. The annual return, along with copies of all certificates and documents, shall be preserved for a minimum of 8 years from the date of filing with the registrar. The board has got a duty to convene an extraordinary general meeting if 1/10 of the paid up share capital of the company holders submit a requisition. In respect of requisition for EGM, the board has to proceed to call the EGM within 21 days of the receipt. Proceed to means it should take steps to send notice within 21 days. If the board fails to conduct the EGM, the requisitionists can conduct the meeting within 3 months on their own from the date of requisition, and all costs will be charged to the company. At the meeting of requisitioning, if the quorum is not there within half an hour, the meeting stands cancelled. There is a method of postal ballot as per the Companies Act where the voting by post takes place within 30 days from the date of dispatch of the voting letter. Postal ballot voting cannot be used for ordinary business because ordinary business has to be conducted in a properly convened physical meeting. Therefore, appointment of auditors, being an ordinary business, cannot be transacted through postal ballot. Any response received in the postal ballot is valid when it is received within 30 days. If it is received after 30 days from the date of issue of notice, it shall be treated as invalid and considered as no reply has been received from the member.